Sexual Assault Statutes of Limitations in New York and New York City by attorney Andrew M. Stengel. Most sexual assault charges in New York have a statute of limitations, but there are exceptions for the highest degrees of crimes, such as rape in the first degree. The statute of limitations for a crime begins to run on the date of the alleged act, and charges cannot be brought after the time expires. The statute of limitations in New York is 2 years for a misdemeanor, 5 years for a felony. However, New York has an extended statute of limitations, which is called the tolling period, for a complaining witness who is less than 18 years old at the time of the alleged sex assault, such as rape, sexual abuse, and criminal sexual act. Some New York sexual assault crimes have no time limit for when a charge can be brought, or a longer time limit. In February 2019, New York passed the Child Victims Act, raising the tolling age from 18 years old to 23. If a complaining witness is less than 18, then the statute of limitations does not begin to run until the person turns 23, unless the sexual assault is reported earlier. The tolling period ends and the statute of limitations begins to run if the alleged sexual assault is reported to a law enforcement agency or the statewide Central Register of Child Abuse and Maltreatment. To repeat, if a sexual assault allegation in New York against a person who is less than 18 is not reported earlier, then the accused can be charged until the complaining witness turns 25 for a misdemeanor and 28 for a felony, unless there is no time limit or a longer time limit. Some New York sexual assault charges do not have any statute of limitations. Under the criminal procedure law, a person can be charged at any time, no matter when the allegation is reported. The crimes include rape in the first degree, aggravated sexual abuse in the first degree, predatory sexual assault, course of sexual conduct against a child in the first degree, and incest in the first degree. Under New York's criminal procedure law, 3 sexual assault charges have a 20-year statute of limitations, or 10 years from the date the complaining witness makes a report to law enforcement, whichever is earlier. Rape in the second degree and criminal sexual act in the second degree when the allegation is lack of consent by reason of being mentally disabled or mentally incapacitated, and certain allegations of incest in the second degree. Under New York's criminal procedure law, 2 sexual assault charges have a 10-year statute of limitations. Rape in the third degree when the allegation is lack of consent for a reason other than the complaining witness is younger than 17, and criminal sexual act, the third degree, where lack of consent is for a reason other than incapacity to consent. Former New York prosecutor Andrew M. Stengel is an experienced and knowledgeable lawyer for sexual assault charges. Andrew M. Stengel is a skilled trial attorney, a diligent investigator, and a tenacious representative. Whether the sexual assault involves an allegation of rape, sexual abuse, criminal sexual act, or any other criminal charge or investigation, Andrew M. Stengel provides expert legal advice and representation. For more information, visit the website of Andrew M. Stengel, www.stengellaw.com, or send an email to info@stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.